of this case leans credence to our position that this petition, as it stands now, does not meet the threshold of Article 64. Indeed, our position today has affirmed this assertion. It is a tried principle of law that there is the right to be heard, but inherent in this right is the right not to speak. The petitioner exercised their right to be heard, and they spoke. We have decided, as the second respondent, not to exercise this right. And in actual fact, a petitioner who has confidence, full confidence in his case, should be happy, probably popping some champagne or drinking some tea, because we have decided not to adduce any evidence. However, it is curious that the petitioner, on whom the burden of proof lies, wants the Electoral Commissioner to mount the witness box in order for him to use the Electoral Commissioner to prove its case. This is not heard of, and our application today was grounded, firmly grounded in law. Lawyers, when we go to court, decide the strategy we want to take. We, as counsel for the second respondent, decided to take this course of action. And we indeed feel that this is the master stroke and has, should I say, has disturbed the camp of the petitioner. And that is why they have made lengthy submissions as to why this should not hold. The court, we are in the bosom of the court, and we know that tomorrow the court will adjudge in our favor. We are hopeful that the court will rule in our favor. Let me land with a quote from Shakespeare in my favorite book, Hamlet, which says, "To thine own self be true, and it must follow as the night and the day. Thou canst not then be false to man." The truth is only one, and the truth is that His Excellency Nana Addo Dankwa Akufo-Addo was validly elected the President of the Republic of Ghana in the 2020 election. Thank you. We'll now take some questions.
Different number of occasions you have indicated to us that Chairman McMahon was always available with his pink sheets. Outside the law, I just want to find out, are you not worried about the optics, in the sense that you have insisted that your candidate won the election? The custodian of the documents, the court says, should not let the petitioner see the documents.
I've already said, as a lawyer, you have your strategy, and you decide which strategy to take at every point in time. We have always said that we are poised and we are at the mercy of the court. If the court decides that we should give evidence, our star witness is more than ready. But it is curious to note that the petitioner has all the documents that he is requesting for. The petitioner has not met the threshold that has brought us to court. Yes, there is a court of public opinion, but this is a court of law. And the reason why we are here is to challenge the validity of the election. It is to determine the 5 issues that have been set down for trial. And as long as these 5 issues have not been duly satisfied, we believe that the evidence that has been adduced does not in any way prejudice our case. So we have decided that as part of our strategy, and we bear the risk, we are ready not to call evidence. And I think that should be something that we should be allowed to do. In the court of public opinion, what it is that the petitioner himself did not testify. That is something we should all ask. Why is it that John Dramani Mahama did not testify in the matter? He is the one who has brought the matter to court. He is the one who, above all and beyond, is personally affected by the matter. So he should have brought the matter to court. When we speak about this court of public opinion, there are other avenues for redress. The Right to Information Act has been duly passed, and it was passed under the watch of His Excellency Nana Addo Dankwa Akufo-Addo. The rights under this act can be invoked. Parliament, the petitioner or any upstanding citizen who wants to ensure that the EC is held accountable, as has been bandied around in court when we are not here to challenge the validity of the election can make formal applications in that regard. So we need to focus on the issues, the 5 issues that have been set down for trial by the court, and know that we are here because there has been a challenge to the validity of the election, and that is what is important. Per Article 63(3), the person who will be elected, who is elected as president, has to cross a 50%, more than 50% threshold. And that is why we are in court. It is not about laying to rest certain allegations that are unfounded. That is not why we are in court.
Just a minor follow-up. Will it hurt your case in any way should the EC chairperson come and speak and confirm what you believe is what actually happened, knowing very well that the people of Ghana have not heard from her, particularly related to how those mistakes which she has admitted to were occasioned?
As I've said already, it is not about whether it will hurt our case or not. We are poised. In any way, if the court decides that we should give evidence, we will give evidence. But as I said, 1, each lawyer has their strategy for their case. 2, and more importantly, we are here to challenge the validity of an election. You, the petitioner, cannot use the evidence of the Electoral Commission to prove your case. No, that is not how it works.
I admit that indeed the proof is on the petitioner in the ongoing matters. But watching from what happened in court today, that your side also opposed that the Electoral Commission, chairperson of the Electoral Commission, who was returning officer for the poll, should mount the witness box and testify. Are you not interested, like the rest of us Ghanaians who are, in knowing what really transpired on the 9th of December, the night of the declaration in question? And also, would it not be more of a validation through the courts that indeed the president was validly elected and validly declared as such? On the matter of whether or not the petitioner has met the legal threshold in terms of proof, is that not left to the court to determine? I mean, in a number of press interactions for a number of days now, your side has always said that the petitioner has not delivered on that. Is it that determination reserved for the court, or it is reserved for your side to share?
The final determination is reserved for the court, but as a lawyer, you assess the case and you decide the strategy to take. In our estimation, the standard which we thought, we expected to be met has not been met. And as such, we think that the court, we pray the court to use the already existing evidence to ensure that it arrives at a final determination of the 5 issues that have been set down for trial. With your second question, I hope I remember. I think it's your first question. The Electoral Commissioner, I keep on saying, this Electoral Commissioner is very tech savvy. All the results, all the documents have been uploaded onto its website. This is an Electoral Commission that even has social media handles. It is in line with the transparency and the need for Ghanaians to know that this information has been put on these websites. So anyone who wants to know what actually happened just needs to visit their website, visit their Facebook page or any other social media handle. The documents are there, and more importantly, the petitioner himself, through his witnesses, has admitted that he has all the documents. So there is no issue as to know what actually happened, because we all know what actually happened, and the documents to support same are available on the internet. And then when you come to the validation, as I said, the court is not here to validate who won the election. The petitioner has brought a petition challenging the validity. So if you are challenging the validity, then you need to show the court why this validity does not exist, or this validity is not what it is. So that is the burden of proof that is on the petitioner. And the court is not to validate what actually happened. So it's going into the actual issues, and that is what we are in court for. So let's always remember why we are in court. It's not about the public opinion, but for legal issues to be determined. Okay. So now I'll hand over to my sister Fati to give the tree translation.
Me nyanma ye shemu ha Ghana nsentrefo ene adehia omagibra omohwe yen wo fie megidi say yen nyina eye ensama ewo election petition mu a eye former president John Dramani Mahama ode abedan court no obi edi so nanso so ansa na mekọ ne nesi wo court dem ho na mekan mo say eye petitioner no ene Ghana for dodo na local and international observers ka ho mun central for cry enam mofidi akese bebre so edi abofo mo ko enkro bebre so ko hwe sa collation na ekoso at the constituency level polling station region and national edi ho adanse epefe say ye de ye nim pefe say president Nana Danko Akufo-Addo aba ye koto on 7 December 2020 no odinkunim prekope sabi former president John Dramani Mahama ena wanting ho asenti ne abepie mu court ha na sabi nsama e ka no court ha na ayaye yi no enyina so ne adanse enya abosremuka na sa obekan a ene da etoso dumiensa a court na sinkonwa wa ha na petitioner na nkasa o say ne bonyo election na ye koto on 7 December ne ekire enkenkan mu petitioner no out of 13 times a court na sinkonwa no wapie mu a ha say premier nu pe nenya no nko a o petitioner no kra na eye court hansama ekoso esunsunsanso onim se ebeka na se ne sebi NDC ni bi a wotu no na abesi ha no ono ankasa kra wanyi ne ho danse ni amfa na danse ama medan court no samo bekan a eye nra petitioner na lawyer for se ensama omode bedan court enyina so enimu adanse enyina omode abegu ewo mu se ansa na court no be start esi nkonwa no na omo ankasa yi court na sutre se nyame adoma adansefo num e na omo be frɛ omo form asemu megu nra na adansefo miensa e na omo frɛ eye owura se edu nketia eye Dr. Michael Pesa White ene owura Rojo Metal Nunu ene adansefo pa omo frɛ say ka say yen sorry ntia mu say kian ne ki esese adansefo mienu omu yi court sutre se omo frɛ omo no omo nkofo omo mra atokos da bi yen ka sa efi se court ha say na ayaba no ye de emra ene ye adwuma enti sa mra na ema petitioner no kwan se ma ne megina adaka mu medi adanse emfa moa ne case no sa mra na so na ma electoral commission chairperson so akwanya se won pese obegina adaka mu abedi adanse de abeboa ne case a ehu hia se obegina adaka mu enti na ye gina ha no na sa obekan so a eye petitioner no na dansefo na lawyer for ensema na omo kan court dem ho no kame aye say omo kira ade ba kope se eye adansefo miensa omo do mbegina adaka mu no ensema ombe toto papa so ne omo de bedan court ni nyina kame aye say antimi ama enyina so nti a adesrede omo de abedan court nanim se court no enka se eye aba ma meji mensa o declare ye no eni emra no bo ebra ana say eye aba ye koto ye no obi ani nkunim enti court no nhye na yensa anya nhyehyɛ foforo na eye former president John Dramani Mahama ene president Akufo-Addo omo nsan kosi aka ni bio no oma dance for miensa na omo begina adaka mu ebe so aye se omo ka no kre no omo mu bia ni hono ma otimi ma adanse a etimi pagya omo koduru mpempen so a court no ebetu no ho asi o se sa de srede omo de abedan court omo de be mo omo enu nti omo se sa de a ene esese ekọ hayo esese ye hye EC chairperson ne keten se wo pe wo mpe wo megina adaka mu ni antoto na no na ehe na wote sesa wo sama obi a nipa na wasama no ono ne sai na so die se obeyi wadanse enya wo wadanse ni nyina so na sesa wo de be dan court no ebio ene obetie lawyer penina na okasama petitioner na o se ai enam se ebra o de adesrede ebeto court batan yanim se nke yema o makwanya na o ntoto electoral commission na no enyi nsemfo abi asa akwanya na ama no na ekire se ne ye nhye se EC ba panyin begina adaka mu na nya sa na court ne kan court no a ruling omode ba ye on that issue of interrogatories no omo say efri say eye ensama na petitioner na lawyer for atwere guru akrata so any set of questions omode be dan court no in interrogatories na ehun hia eye irrelevant enti na court no bogu ye court na antwere wo ruling no mu say enam se na ma me na twere e wa affidavit mu so onya akwanya say obegyina adaka mu obeyi nsem na no nti ma na nya nti san nsem na omo keka wa ha se ni nyina emfa kwan mu ebio mehu se petitioner no ne kasamafo ne lawyerfo ne bi begina adaka yanima omo ka kire mo se ai emese court dem ho de mrakwan mu de bia ne ani nkunim enti yamfa propaganda mbeda ga na adehye na omo nka ya asem maye na ada wunsura adenti na amegina adaka mu accountability nti adenti na amegina adaka mu ye nyina ye nim se ga na adehye ya na musifo wo mrahye bedwam a se ba no nkontabuo ne accountability a sabi omutimi frɛ isi no anase isi na adwumayefo ebrebia emo bebu nkunta kyerɛ Ghana adehye through parliament emo ka sɛ adwuma amode maaye no mpempenso a ya akoduru ni na ha ne yede yekɔ ɛna court na ya ba begina ha no ɛyɛ petitioner no ankyekere yɛn sa begina court ha se oba for accountability also oba se declaration na isi ba panyi ɛyɛ no ebu ɛyɛ Ghana mrapon no article 63 clause 3 nti ne ejina ha o say declaration na ma me ne na ebu mra because obia anya 50% plus o say ebu mra because onu no ahoma bi a eye nkontabuo num na ankoso ye ogidi say betima ye nsakyeraye e wo results num enu nti ne ejina ha enti se ne nipa ne begina ha na nsemfua na onu no de beda Ghana adehye ema enu nyina so nti omutu emabunugu monten so ema ebi hwere omunkwa ebinya ankwanhia ebinya abayamane no begina court one for sansemfo no mu bia medan court na ebewi ase no o se ye megina for accountability nti amesre mo omo ba mo kan omo se enye anu nti na omo de ebegina court ha sei ebio se petitioner no accountability de so omo pa enye oba akofo ho ene eje accountability yenye bin free petitioner no ho sa ono ana Ghana fo akohoma a free aban no fotuom ene ye nyina ye kotokuom ye keka bo mu de ma isi ne so mo nko conduct election enu nti na candidates edumienu a no mo ye presidential candidate omu nyina na musifo ye mo carbon copies of aye pink sheet any coalition sheets from polling station constituency region and national na accountability nti na nka ehu behia se omampanyi dada se ode asem we ba court abetwema nso a enko obeka se mene mama nyokuo enam accountability any deals no nkuni obu a ye wo Ghana adehye nti enka nkonta ye bu ye no esunsunso aso ni na nso so omo begina court ha omanfa accountability no ho nkonta ama amfa ho adanse ama na oma begina ya kase da bi ye de ye ni aso de bia ama Ghana fo na oma hu so oma di nchonti eno omo de abegina ha sei adwane afiri nsam omo de beda court no ebe pre foforo se ne enemu nyina mu sete ye no ya ajaje for mutena adwam omuti obi anu asem eye second respondent a lawyer for me papa odi anim eye oru akoto ampaw ogina amra so isi lawyer panyin so eja se na menu wo no so gina amra so ese sa wo hwe eye high court civil procedure rules eye CI 47 no ma sa wo hwe order 36 rule 4 sub rule 3 ene order 38 3e 1 any 5 as amended by CI 87 na yenshe obisa o megina adaka mu media dansie emra no enye sa na mra ne kire enti se wo beda court a oba fi se unim se wasem a wo de ba no emu odu enya atentenhuo enya asawa unim asem a wo de beda court enti na abaye ye medru court ha nwie emeka sa madansie no mu oha enti me baba beji adansie afri nipa amene no pre wo court ha no ho enti mesre mo se nsem na ya no mama na kofom na Ghana fonzo so ate ase se sabi ne wa beda court e de akinye aba beto ha no ono ena se ode ne nyina so ene na dansie ba enti nyame adom o kina se court no sa sin eye nyame adom a ya wada napa court no besi nkonwa na enne ensem a epie mu application a eye first and second respondent a lawyer for the abedan court no wa bebua na eduru ho nso ye de no mu nso nkyeremu bebre mu medam nyina amase. Thank you.
My ladies,